Thank you for your service to the Muskogee Planning Commissioning Board. Here are a few things you need to know to be a successful board member. The Oklahoma Open Meeting Act is intended to encourage and facilitate a citizen's knowledge of government. Or in other words, it's just to let people know what's going on. The act also helps citizens understand governmental processes and problems, while also making meetings convenient and open to the public. Rules of open meetings include ensuring that all meetings of a majority public body where business is discussed are required to be open to the public. Discussing items solely on the agenda. Remember, if it's not on the agenda, it cannot be discussed. The discussion must be limited to particular agenda items, so be careful about deviating topics. For example, if the agenda is about revising park rules, you can't talk about which parks need to be mowed. The agenda must also be written in plain language and must indicate the topic to be discussed and the potential action to be taken. The vote of each member must be publicly cast. Roll call voting is not required, but it does ensure each member has cast his or her vote. Minutes are required to be taken, and violations are a misdemeanor plus civil liability. There are 4 types of meetings. Number 1. Regular. These require notice of meetings to be filed with the city clerk by December 15. They must be posted on the city website, and notice and agenda must be posted 24 hours before the meeting as well. If the location, date, or time changes, 10 days of notice must be given. Number 2. Special. 48 hours of advance notice must come before the meeting, and it must include the time, place, and location. This notice can come on the weekend. The agenda must be posted 24 hours in advance, but for this case, they cannot come on the weekend. Agenda items of new business are not permitted on special meeting agendas. Number 3. Emergency. These require as much notice as possible and involve a situation involving injury or damage to a person or property or immediate financial loss. Lastly, number 4. Reconvened. These require notice to be stated at the time of recess. This meeting is typically used for finishing up business or taking a break. The agenda cannot change between the time of recess and reconvening. Executive sessions are an approved exception to the general rule that a meeting must be open to the public. It is only allowed in certain circumstances, and there are 7 which are applicable to cities and 3 for municipal boards. These matters include discussing the purchase or appraisal of a real property, confidential communication between a public body and its attorney, or the purpose of conferring on matters pertaining to economic development. Motions cannot be made in executive sessions. According to the city charter, no board or commission may expend city funds, enter contracts, leases, or other agreements involving public property without the approval of the council by resolution or ordinance. The charter also states that council appointments to all boards, commissions, and trusts will, with the exception of the Merit System Board and Civil Service Commission, be for the initial term provided in the charter or by ordinance. An appointee will not be eligible for reappointment until 1 year shall have elapsed. This only applies to a full term. So, for example, a person filing an unexpired term can be reappointed to serve a full term. The Board of Adjustment exercises quasi-judicial powers for all zoning matters. Appeals from decisions made by the Board of Adjustment are decided by the Muskogee County District Court. The BOA hears appeals and decides appeals filed by any person impacted by a decision of any administrative officer of the city. This is typically the planning director. The board can modify the order, requirement, decision, or determination. If an appeal is warranted, it must be filed within 10 days with the stated grounds for appeal. A filed appeal stops any further action until the appeal is decided. The BOA has the power to Hear and decide appeals where it is alleged that there is an error of law in any order, requirement, decision, or determination made by an administrative official. Hear and decide special exceptions to zoning regulations to allow a use which is not permitted by right in a particular district, or grant variances if warranted. It should be noted that special exceptions and variances which are granted by the board are void if they are not utilized within 2 years. What is a variance? A variance is a request to deviate from current zoning requirements. What is a special exception? That's permission to allow a specific use within a zoning category. The BOA may impose appropriate conditions and safeguards in granting a special exception so long as the conditions are in harmony with the general purpose and intent, and only in accordance with the general and specific provisions in the zoning regulations. What's the difference between a variance and a special exception? Both are requests for relief from zoning ordinance. Both run with the land, meaning they continue to exist regardless of a change in ownership. A variance is an excused violation, while a special exception is conditionally permitted use. Variances are granted based upon 4 factors. Special exceptions conditions are set forth in the ordinance itself. In both a variance request and a special exception request, the applicant bears the burden of establishing the necessary criteria in order to get it. In granting a variance, it is the applicant's burden to establish the variance would not be contrary to public interest. An unnecessary hardship would arise if the ordinance were literally enforced. The spirits of the ordinance would be upheld, and substantial justice would be done by granting it. In determining whether or not to approve a variance, the board should discuss the 4 above factors and make a determination on the record finding that all 4 have been met. The Board of Adjustment has significant authority in determining any special conditions that may be imposed upon granting a variance. Special conditions may take the form of limitation on articles to be sold, closing hour controls, requiring fencing, limit signs, or restricting lights and signs. Pitfalls in requiring special conditions on a variance include special conditions with no reasonable relation to the health, morals, safety, or general welfare of the public would likely be set aside by a court. You cannot require dedication of a part of the land as a special condition, because that would be considered as a taking, requiring compensation to be paid to the owner. Variances and special exceptions, which go unused for a period of 2 years from the BOA's decision, are void thereafter. Special exceptions that are granted stay within the land, even if the person asking for it sells the land to someone else. Special exceptions that no longer matter should be terminated, such as one that allows a property owner to have a bed and breakfast, but sold the property to a new owner that is not going to run a bed and breakfast. The standard of review of a BOA decision by the courts is as follows. It cannot be arbitrary, unreasonable, or capricious. It cannot create an undue hardship, and it cannot create substantial harm or loss. It is a responsibility of the planning staff to make a recommendation on items on the agenda. Recommendation will be solely based upon City of Muskogee Municipal Code and the City of Muskogee Comprehensive Plan, as well as any applicable state law. Staff can answer questions as they pertain to the municipal code and will convey any public comments from the general public. It is the staff's responsibility to offer an unbiased interpretation of all zoning, specific use, and special exception requests. Staff may discuss how applications comply or deviate from the comprehensive plan and/or the municipal code. Staff may not give council members their personal opinion or subject review of applications. Board members may ask staff questions regarding code or comprehensive plan interpretations only, not for their personal opinion. For example, an acceptable question is, how does the submitted application comply with the underlying zoning district? A not acceptable question is, do you believe that this application would be a benefit to the city? The board may contact staff for clarification prior to a meeting. Ideally, Board members should email correspondence to clarify portions of staff reports prior to a meeting. If a request is received verbally, a follow-up email should be shared with all board members. In accordance to the City of Muskogee's Code of Ethics, board members are charged with complying both the letter and spirit of the laws and policies affecting the operations of government, being independent, impartial, and fair in their judgment and actions, not using their position for personal gain, and conducting deliberations and processes openly in an atmosphere of respect and civility. The conduct of board members should be above reproach and avoid the appearance of impropriety. Abusive conduct, verbal attacks on character, and motives should be avoided. Board members should be prepared, listen courteously and attentively to discussions, and focus on the business at hand. Comments which are not germane to the discussion should be avoided. Board members should also not use public resources not available to the general public for private gain or personal purposes. Board members should be mindful of their resources as stewards of public money and should not present a position nor advocate in the interest of private entity. If you are aware of unethical conduct, state it, or if it requires investigation, notify the city attorney. Article 10, Section 11 of the Oklahoma Constitution prohibits benefiting, either directly or indirectly, from the use of public funds.
The steps on how to make a motion are as follows. Step
After
1.
being elected by a
Member
majority of
obtains
the members,
recognition
the
by the
duties of the chair include
Step 2.
keeping the meetings
Member
orderly,
states the
following
motion.
the meeting rules by
I
allowing
move
members
to
to
approve
speak,
the minutes
managing
of the
time and
July 8th,
procedures, and
2019
overall
meeting.
helping the board meet their goals.
This type of motion
Remember,
is a main
the chairperson
motion.
only has
Step
the authority
3.
expressively
Another member
granted by
seconds
ordinance
the motion.
or by specific acts of the
Here,
board.
recognition is not necessary. Step 4.
Further chair duties include
restates the
collaborating
motion
with staff
for the assembly.
liaisons and working with
It has
staff
been
to create
moved
purposeful
and seconded
agendas,
that the minutes
leading
of the
effective
July
meetings,
8th,
and
2019
engaging board
meeting
members to
be
discuss
approved.
and deliberate
Step
agenda
5.
items.
The motion is debated.
The chair should also
Step
control
6.
dominating
The
or
chair
unproductive
calls for a roll
behavior
call vote.
during meetings.
And Step 7. The chair announces the result of the vote. A main motion is one which brings business before the body. An example of a main motion is one which follows an agenda item. Any member can amend a main motion, but must be done prior to a second. Instead of making a subsidiary motion, a member may state that if the main motion fails, they will offer a substitute. This lets the body know other alternatives so it can make an informed decision before all votes are counted.
Thank you again for your commitment to Muskogee. We are excited that you've joined our team, and we look forward to celebrating your success.